Hi there, my name is Brian Koegle and I'm the president of Koegle Law Group. And today I'm here to talk to you about the importance of making sure that your business is keeping track of tips under the new One Big Beautiful Bill Act that was passed by our legislature back in July of 2025. The reason this is so important for so many California businesses, especially restaurants and those of you in the service industry, is because the rules are very complex. And as we look at the differences between the federal law, the One Big Beautiful Bill Act, and what's required in California, you can find yourself in conflict very quickly. The importance of being able to make sure you have good documentation, tracking the amount of tips that your service employees are receiving on a day-to-day basis is going to become essential as you move forward, especially for tax year 2026. It's incumbent upon employers to make sure that they're properly tracking the system. Most importantly, there's a misnomer out there that just because there is this new federal bill that says there's no tax on tips, it doesn't change your obligations as an employer. You are still required to make sure you're making all lawful federal and state deductions from tips that are received by your employees. The employee then is able to file in their tax return at the following tax year for a refund of those taxes that were paid in the year prior. They'll still be subject to FICA. They'll still be subject to Social Security and Medicare taxes. And most certainly, they will still be subject to California state taxes on all of that revenue. So it's imperative for businesses to ensure that they're getting all of those taxes held back and paid to the appropriate taxing agencies on a regular basis. Additionally, one of the other misnomers here is no tax on tips is not an infinite number. In fact, the cap on non-taxable tips is $25,000 per calendar year. And then finally, there's also a phase out of this provision that provides that if you have a very high income earner, someone who's earning more than $150,000 individually, they will no longer be eligible for the no tax on tips deduction at the end of the year. And here's where things get really interesting. There are many times where an employee is earning very high tips during their work week, where so much so that it may exceed what they're making on their minimum wage that they get paid from the company, which is an absolute certainty and necessity under California law. You cannot compensate any less than the minimum wage and offset that by tips. So what happens in the circumstance where the person's tips were so far exceeding what they were paid in minimum wage that the taxes that are charged on those tips, especially for cash tip businesses, exceed the income of the employee? Well, in those circumstances, many employers will have to claw back additional monies from the employee in order to make sure that they're covering the appropriate tax sums that are due to the taxing agencies. That may mean that the employee has to give you cash. It may mean that they have to sign a written agreement that they're going to have this deducted from future payroll systems. There are lots of different ways to handle this. However, I will tell you many of the employers that we work with where cash tips are very prevalent and it's really the majority of the income for the employee are very often having to go and collect money from their employees to ensure that there's enough money in the till to pay out those tax on tips.